Or does call the case of James Semenek versus Travis Ackerman and Nikki Meltzer. Counsel, state your appearance.
For the record, Tom Ellis appearing on behalf of the plaintiff and the president of the
Your names?
Travis Ackerman.
All right. You folks tried to resolve this matter or no? We're just going to go to trial. Pardon?
We attempted this weekend. And we did not come to a resolution.
How close were the parties before we go into this?
Not very close, sir.
Mr. Ellis, you'd agree with that?
Yes, Your Honor. The defendants do not feel that they owe any money.
On this matter, then, this is the date and time set for trial on the Semenek matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages, and I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
It was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to amend. It may have been filed in Saline. When did you reach out to obtain a copy?
Hmm?
Do you need me to reach out to obtain a copy?
I've got one in front of me. When did you guys get a copy of this?
It was dated May 21st, 2024.
Say a few days
A
after
few
that.
days after that,
In what?
just before heading into Memorial Day weekend.
21st?
Yeah, this was dated May 21st.
For what date did you, the postmark? What is that?
Postmark on May 21st right here is the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
That is exactly what, is that what you said?
Yes, sir.
Your Honor,
No, I don't, just answer my question.
yes, sir.
That's exactly what they said.
they did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree. That's fine, but that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem. They're entitled to answer, first of all, the motion to amend, and this is the procedural route. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it says on the 17th, they don't get it till then, so they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I've answered it, sir.
That was an unfair question. Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see it, the numbers that are there? All right. Without telling me why, because you don't, I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no recollection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Stammer back for that.
Okay, but
We won't
let me,
I don't have a problem with that.
pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not
have no problem with that amount? Okay,
every year.
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes, sir.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court. And they never answered the complaint.
So the landlord tenant proceeding, they can answer orally. Jeez, oh Pete. Know the procedure before you walk in, counsel. Court's gonna stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Thank you.
All rise.
Court recalls the case of Samanek versus Okerman and Meltzer. All right. Couple of things here. First thing is the motion filed before the court. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint. Mainly because it doesn't. It changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it. However it gets resolved through trial. Having said that, the other problem then arises. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer, which I would grant the motion. So let me make it easy. All right. So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint. Okay. And basically it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. And I know I'm talking in legalese and I'm trying not to. Okay. A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted. The remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit amendment of the complaint. All right. Got it so far? When a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days. Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Then adjourn the non-jury trial to, on the way out the last time, my understanding is there are nuptials that are to be occurring. So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does that.